Well, it's around that time right here on KAZ Radio where I have one of my most hottest once-a-month shows, none other than Family Court Secrets with Maryann Dybiec and Attorney Cherry. How you guys doing today?
Doing great. Looking forward to another wonderful show. We got some great guests today that we'd like to introduce right now. We've got Judge Michael Donnelly running for the Ohio Supreme Court and Michelle Sheehan running for the 8th District Court of Appeals here in Cuyahoga County. And for those of you who don't know, that's our appellate court right here in Cuyahoga County. And they are great guests. Thank you so much for joining us.
Thanks for having us.
Thank you.
Maryann?
Yeah, we're going to hop right to Judge Donnelly here.
Sure.
For people who don't know you, who are you? What is your background? Where do you currently work?
Sure. For the last 14 years, or coming on 14 years, I've had the privilege to serve as a Common Pleas General Division Judge in Cuyahoga County. I started my career as a county prosecutor under the late, great Stephanie Tubbs Jones, and from there I went into civil practice on both sides of the aisle, and in 2004 I was fortunate to win a seat being vacated by retiring Judge Burt Griffin at that time. So that's where I've been for the last, coming on 14 years now.
And for the people who are listening who really don't understand the judicial system, what kind of cases do you hear in Common Pleas Court?
Sure. The Common Pleas Court is the general trial court for the state of Ohio, and we hear both criminal cases. I have a criminal docket and civil matters. And criminal cases that originate in my court are all felony level, so the more serious crimes, criminal crimes, are heard and resolved in our court. And civil cases, we hear a great variety. We do not have a limited jurisdiction like the municipal courts of 15,000, I believe, is it? I think last time I checked. But we have no ceiling or no floor in terms of the amount of money damages that can be involved in civil cases.
Yeah,
So,
I was gonna ask, what
yeah.
does that mean?
So, yeah, it's an interesting job because we're presented with disputes all the time that are with interesting fact patterns, and that's what we do in the judiciary. We resolve disputes. Every case that comes before me, whether it's criminal or civil, is an accusation and a denial, and it's the court's obligation to resolve that so people can move on with their lives.
Find out who's telling the truth.
Right. Well, that should be the main objective,
Is that
yes.
a hard job?
It's a great job. It can be
Is it
hard.
hard trying to figure out who's telling
Yeah.
the truth anymore?
You know, after 14 years, I continue to remain in awe at the design of the system. When everybody's doing their job right, when the prosecutor is seeking justice and truth, and the defense lawyer is defending the rights of the accused, and the judge is being fair to both sides and enforcing the rules of evidence and procedure, and the jury's following the law, there's no better system in the world for finding the truth and seeking justice. You know, but when one of those things isn't working correctly, that's where you have the potential for injustice.
Now, you believe that your role as a trial court judge puts you in a more advantageous position to be a candidate for Ohio Supreme Court. Why don't you talk a little bit about that?
Yes, I think I bring something to the table. But being at the trial court level, and I've also been a vice president of the Ohio Common Pleas Judges Association in the state, and we get together once a year in the summer for conferences, and I go to both conferences. And, we run under party banner in this state, which is unfortunate because nothing we do as judges has anything to do with Democratic or Republican politics. Yeah.
That's a big deal for me.
It is, yeah. I mean, I get together with judges throughout the state, and when we get together, we don't talk about partisan politics. We talk about how do we improve the judicial system and make it fair for everybody, because the courts are there for whether you're Republican, whether you're Democratic or independent. And getting back to your question, as a trial court judge, I see we have great trial court judges throughout the state, but systemically we can do better. The system is constantly improving itself. It's improved itself while I've been on the bench. When I started, we didn't have what's known as open discovery in criminal cases. The prosecutor wasn't required to turn over witness statements like you get now, and all the evidence that is going to be used should the matter go to trial. Right now, we didn't have that when I first started as a prosecutor. I used to read police reports to the defense attorney, and they'd have to take notes and trust that I was telling them the truth about everything that's in there. But fortunately, the lawyers of the state and the judges and the defense lawyers got together and they advocated and said, this is not right, it's not fair. We need open discovery, and it's been one of the greatest advancements since I've been on the bench. So there's new ways. We have to constantly be asking questions on how we can improve the process. You know, the citizens of Ohio deserve a system that is focused on efficiency, resolving disputes in the quickest way possible, but always focusing on the truth behind the matter.
Okay.
So Michelle, a little bit
Yes.
about your background.
Well, first I'd like to echo a little bit about what Judge Donnelly said about, you mentioned party affiliation.
Yes.
And for the listeners that don't know, there is no D or R next to our names on the ballot. So it's really important to get to know
You're right.
who are these candidates. Nobody acts because of a party reason. Everybody wants justice, right? Everyone wants
Right,
to see the
right.
truth. So we appreciate the opportunity to share who we are so that your listeners get to know who the qualified candidates are. But for me, I'm a first-time candidate. I have not been on the ballot before. I've been practicing law for 25 years, 27 at my current
And you have a
firm.
ton of accolades I read in the paper.
Well,
ton.
I
I don't think we have
subscribe-
time to list them all, but
No, I subscribe to the theory of you be a good lawyer and the results will follow. And so my entire career, I was kind of raised under that theory of be a good lawyer, do really good work. And so for the past 25 years, I've been practicing primarily civil litigation, also trying to get as much exposure both on the plaintiff and the defense side of matters as I can. And I've really enjoyed it. And so now the Court of Appeals, we were talking a little bit beforehand, oversees 5 different courts, really reviews those decisions of 5 different courts. Judge Donnelly's court, the general division, is the primary court, but it also involves domestic relations, probate court, municipal court, which one am I forgetting here? Probate, domestic,
Juvenile.
and juvenile court,
Yeah.
thank you. Right, so I've always tried to get exposure on all those, but as you know, with civil litigation, our goal as attorneys is to be problem solvers, just like the judges. Get to the point, what's the most efficient and effective way to resolve it, if it's trial, if it's mediation, whatever it is. But our job is to look at both sides, because I would do my client a disservice if I didn't look at the good and the bad. You evaluate both sides and provide that advice to your client and proceed. And so for me, running for the Court of Appeals, it's very similar in the sense of evaluating both sides of the issue and applying the law fairly and equally. I don't know if I answered your question, but
well, I'm gonna go some. There, Eric was telling me, and I read this also. What is the certification for appellate? Something? What is
You're a
that?
certified appellate specialist, and at
Which,
least for
from
me,
what Eric told me, is like nobody ever does that. So
it's very rare. From
it's
what
either very unique or I'm a big geek. I'm not really sure what it is. But the Ohio State Bar Association started to allow lawyers to become certified as specialists because ethically we're not allowed to say we are a specialist unless there is some organization that qualifies you. So the Ohio State Bar Association has put forth standards for a lot of different areas of the law, one being appellate, and there's only 28 of us who've gone through the extra credentialing. And one of the requirements is 1/3 of your docket of my cases are either appellate or complex legal writing. So at any given time, 1/3 of my docket is actually practicing the area of the law that I hope to aspire to. And so that's how I became, and it's a little mini bar exam, it's a whole lot of different
Sure.
things.
Really?
But,
yeah, he was pretty excited when he told me. I'm like, what is that? He's like,
Yeah.
you just don't even know.
Well, I think that, this actually would apply to both of you, so if you care to answer either of you. I think a lot of our listeners, and many people generally, just don't understand the difference between the fact-finding level at the trial court and what happens at a court of appeals or at the Ohio Supreme Court that's different from those two. And so the fact that you have the kind of experience you do practicing appellate law, I think is, at least to me, is a highly qualifying factor for the 8th District Court of Appeals, because you know the difference between the fact-finding level and you practice it on a daily basis to do the legal work that happens at the Court of Appeals. So to the extent that either of you would care to comment on the difference to elucidate our viewers.
well, I know he'll jump in, so I'm gonna jump in before him. It's really unique because we're covering generally all 3 areas of the law, and what I tell everybody is everyone hears about United States Supreme Court, right?
Sure.
Everyone thinks, they talk about who these judges that are getting appointed to the Supreme Court. And I always say the federal system and the state system mirror each other. If you look at a box and there's 3 shelves, there's a trial court, a court of appeals, and a Supreme Court. And the state level, it's the Ohio Supreme Court's at top, Court of Appeals, and the trial court. And the federal level is the United States Supreme Court, Court of Appeals, and the trial court level. But the big difference is that the president appoints the judges in the federal court. Your listeners get to elect the judges in the state court.
Do you hear that, everybody?
It's a really great system that we live in. And Judge Donnelly has had a wealth of experience on that trial court level, and he will be unique and provide a great expertise in the Supreme Court level. For me, on the Court of Appeals, like you said, I've been a certified appellate specialist. I have practiced and tried cases in state and federal court in the trial court level, all the way through the appellate level, and have been fortunate to argue before the highest courts in our state, the Ohio Supreme Court, the Sixth Circuit Court of Appeals, and literally almost every court of appeals in the state of Ohio, traveling around handling appellate matters. So qualifications are really important, and I think voters, they think just because you're a lawyer, you're qualified. And you need experience in the court you're seeking, and I think that's really important. And Judge Donnelly?
I agree with you. Our system is built on checks and balances, and at the trial court level, we are making decisions, at a rapid pace, and trials are coming at it, and we're making split-second decisions after listening to the attorneys. And so there's this misperception that the trial courts have this adverse opinion of the appellate courts. I'm actually very glad that they are there, because when I make a decision, I want someone who believes that I made an incorrect decision to have some recourse and go before our 3-judge panel at the 8th District and say, look, Judge Donnelly didn't follow the law as he should have in this particular case, and this is why. And, that's why I'm glad they are there, because it's kind of like an emergency room in terms of making the decisions that we make every single day.
Calling balls and strikes.
Calling
You just
balls
call
and
them as
strikes,
you
yeah.
can.
And so some of those decisions are easy, some are difficult. Sometimes the law is unclear, and you're making decisions interpreting the law that go up to the appellate court, and sometimes all the way up to the Ohio Supreme Court, which will become, if the ruling is followed, the law of the state of Ohio. So.
Well, and the other important thing for your voters to recognize, a lot of people don't appreciate that, like Judge Donnelly said, the trial court, they're there for balls and strikes. They do the best they can. But when there's a really meaty, substantive legal issue, you want someone to take the time to review that. And that's the Court of Appeals, where there's 3 judges reviewing that issue. The Ohio Constitution gives you a right to appeal to the Court of Appeals. They don't give you a right to appeal to the Ohio Supreme Court. Those are they get to pick and choose what cases they take to create the law, which is why that court is so important as to what issues are taken in and what issues are addressed. That will be binding on all courts.
Right.
That was important information. A lot of people just don't realize that.
Right.
Thank you.
Okay, go back to Judge Donnelly for a minute. There's a couple of issues that you are really advocating in your campaign that have a lot of bearing on the criminal justice system.
Sure.
And I think that many of our viewers and listeners, through their families, have had some interface with the criminal justice system, probably have some bad stories to tell. Would you care to tell our viewers what you're advocating in your campaign?
Sure. I've been traveling this state talking to Ohioans about how I believe the criminal justice system can be improved, from the early stages through the charging process, through bail reform. There's a host of areas that need improvement. But if you Google my name, you'll find that I've advocated for transparency in the plea bargaining process here in the state of Ohio for the last number of years. 97% of all cases, as you're aware, don't go to trial. They're resolved through negotiated plea agreements. And there's a lot of mystery and, frankly, some suspicion in some areas of our community about plea bargaining, because a lot of these plea deals get hammered out back in judges' chambers with the prosecutor and the defense counsel, but no court reporter. And I began to question this process early on in my career, in my first term, because I thought, well, there's 2 important stakeholders that are being left out of the process. If the criminally accused, whose life's going to be affected by what's being discussed back in chambers outside of his or her earshot, and if there's a victim in the case, they get left out of the process. So after thinking deeply about this, I came to the conclusion that no one should ever say anything back there off the record that you wouldn't say verbatim. So one day I said to my bailiff, John, let's stop having these discussions back here, because we can have the discussions outside, on court, on record, and that way everybody's held accountable, including myself. And in plea bargains, what people don't often realize, the defense or the accused is bargaining for something, a benefit usually in the form of the consequences of what is going to take place should they choose to enter that plea agreement. And as you know, every single day we have this plea colloquy. Has anybody made any representations to you about what sentence you'll receive? And often they say, no, that's not. Well, why would you say no to something that you are contracting for? I mean, I think from the accused point of view, it's perfectly reasonable to know within reason what your benefit you're negotiating for. So ever since my first term, we've been doing that on the record. That way, everybody's accountable, the prosecutor, the defense lawyer, and myself. And if we want to talk about what type of sentence is being advocated for, we do it. And if I go along with it, I'm on record. I can't change my mind 30 days later if I'm having a bad day. And I hear stories like that of people being induced into plea agreements when they're told that they're going to get probation and something totally opposite happens 30 days.
Really?
And when that happens, people lose confidence in the court system.
Certainly.
So I'm advocating for factually based pleas. Your listeners, if they want to Google my name along with plea bargaining reform, they'll see that I've advocated. I found some disturbing results, not only here in Cuyahoga County, but statewide. Cases were coming into the system alleging the crime of rape and other forms of sexual assault, and they were prosecutors were allowing, in some instances, defendants to admit to a crime known as aggravated assault. Now, the public doesn't know what aggravated assault is, but I'm representing to you right now. It has absolutely nothing to do with rape or any other form of sexual assault. It's a low-level probationable felony that is actually used to plea felonious assault cases out when you can't find out who started the fight,
Right.
because there's a mitigating element that the victim provoked it.
Right.
So I thought this was wrong, and I advocated for a rule all the way up to the current Ohio Supreme Court that would simply say this: if a prosecutor presented a charge that didn't even resemble what you originally charged the person with, you'd first have to state facts on the record that, if true, support what the person's about to admit to resolve the case. And as I travel around Ohio and talk to the good citizens of Ohio, and I say, does this sound like a radical position to you? And they say, no, what happened? And I tell them, and it went all the way up to the current Ohio Supreme Court. And in January 2016, the current Supreme Court rejected this measure without comment. When the press called them up, they said, can we hear what your reasoning for rejecting this? And they said no. Ooh. And it resulted in the unfortunate headline that you can Google, your listeners can Google in the Dispatch: Ohio Supreme Court rejects truth in sentencing rule. Ohio Court rejects truth. That
doesn't ring very nicely, does it?
No,
right.
it really doesn't.
So that's something I'm going to continue to advocate for if I'm successful in this race.
Would you advocate for that statewide in every court of common pleas, or?
Yes, and already, this isn't a rule I came up with. It exists in the federal system. You cannot plea cases out unless there's a factually based plea. There's this beautiful fountain down next to the Ohio Supreme Court, and there's a title to it. It's called In Principle and In Practice. And it has all the tenets of the justice system that we're supposed to be working for: truth, integrity, honesty. It doesn't say legal fiction. It doesn't. It doesn't say resolution to the most powerful or the highest paid attorney. It doesn't have those things there. It says truth.
Would such a rule make it more difficult to potentially plea cases out if there's no available lower felony that would fit a fact pattern that mirrored in some way the facts that were alleged, and therefore make cases unresolvable and create more trials?
I don't believe so, because I have a blanket policy in my room, and it hasn't resulted in more trials. And
Okay.
if prosecutors feel that they don't have a good faith basis based on the evidence that they're guilty, they just dismiss the charges, or they find alternative ways to resolve it through diversion, or they just don't plead to something like a legal fiction. Like, I have documentation of downloading child pornography being pled out to felonious assault. Now, that doesn't make any sense, right?
No,
I mean, so the citizens of Ohio deserve to believe that the outcomes of our system are based in truth or fact. And if we continue down this road of allowing this to happen, then they're going to lose faith. Because employers, future sentencing judges, we all rely on the information that comes out of our system to be truthful, to make important decisions. When I sentence someone, I want to look at their background, and I want to know what did they do in their past to make an assessment on whether they're dangerous to the public or not. If that information is false, then we make poor decisions, and that's why we have to always focus on the truth. The truth should never take a back seat to resolution in our. So I don't think I think the fear, when open discovery was being advocated for in this state, there was a fear among prosecutors that it would be open season on victims, that victims would be hunted down and intimidated in case it hasn't happened. And there's mechanisms right now where if there's a real legitimate fear for protecting victims, we can do that. And we can't let the fear of, we're the trial court. We're supposed to be trying cases. And if someone's not guilty, then they should have their day in court. They shouldn't be coerced into a plea by something that they didn't do. Here's something, you can get out today and plead to this aggravated assault. It has nothing to do with what you're charged with. And you can get out today if you plead because it's a low-level probational felony. That's what's happening, and that should end.
Wow.
Fair enough. All right. Well, you want to comment on anything about
Well, I would just say, we see all the time people trapped as lawyers. You see them trapped in the system. It's a system, and unfortunately, if they're not guilty, it's a long system and process they need to go to. And to Judge Donnelly's point, I got involved with a lot of pro bono work because I'd see people trapped in the system and they couldn't represent themselves and they couldn't afford a lawyer when oftentimes the charges should be dropped or there wouldn't be any reason. So one of the things I'm advocating very much so in having the appellate background that I do is it shouldn't be about who you can afford as a lawyer. Just because you can afford a better lawyer that can argue a better brief, it's still on the judges to evaluate the facts. The facts are the facts, and apply the law fairly. And it shouldn't just be a matter of what's in those briefs. It's our duty to go through the record and to find out what is available and apply the law properly.
Okay.
So I'd agree with that.
And is that how you intend to practice at the
I hope so.
district?
And we analogize to the federal court quite a bit, but there's nothing better than having a case in the Court of Appeals. The briefs argue the two sides, but the opinion comes out with information that wasn't even argued in the briefs, but was part of the record. I say that's someone who's doing their job, digging in and really learning the facts, what's part of the record, and applying it properly. That's what I hope to do.
Fair enough.
Thanks.
Yeah, interesting. We only have a couple more minutes with you two, so before we have to end with you, I have one question from somebody who wrote in. Need my glasses. Shelby, and she had a question about how do attorneys get disciplined?
Well, attorneys and judges are all bound to follow what we call the professional rules of conduct in the state of Ohio.
And what if their client feels that they're just not representing them well? We're going to file a complaint. How do they actually do that?
If they feel that an attorney or a judge has violated one of those rules, they can report that fact to the Office of Disciplinary Counsel in Columbus at the Supreme Court.
So do they look up Google Disciplinary Counsel
Yeah,
in Columbus?
they could do
That's
that.
what they do?
It's
Yeah.
actually very easy to
Yeah.
report somebody.
See,
start
and
an
so many people
investigation.
just don't know about that.
Right.
Mm-hmm.
And you call, you can either write a letter or you can call and talk to disciplinary counsel down there, outline what your allegations are, and they will open up a file and they will do an inquiry, an investigation into any allegation of misconduct. And that begins a process. If they find that there is probable cause to charge an attorney or a judge with a violation, they will begin a very elaborate process that will go through, and the attorney is given notice, the judge is giving notice, and they has to answer that. And either if they find substance, then they'll go through the process, and the Board of Professional Conduct has the ability to sanction attorneys to the point of disbarring them, as well as judges. And then the matter goes to the Supreme Court to decide whether, usually it's a question of was the sanction too harsh or whether too lenient. The Supreme Court has the ultimate say on what the consequences for the attorney or judge who violates the rules would be.
And for your listeners, the easy way to go about it is the local bar association, the Cleveland Metropolitan Bar Association. They can contact them and they have a whole process to start.
Can you give me some idea what would actually be an ethical breach?
So many.
You're right.
Yeah, there are quite
There
a
are
few.
so many. 'Cause,
There's a
I mean,
code of
everybody
professional
complains.
ethics.
Everybody complains about their attorney, especially when they don't win.
Right.
But just because you lost and you don't like your attorney doesn't mean you can go file a complaint on your attorney. It has to be substantial.
No, I'm
correct?
sure that disciplinary counsel receives an abundance of complaints like
I'm
that.
sure
that
they
where
do,
where they
right.
do, and they investigate it, and they send a letter politely back and say exactly what you just said. You know, just because you didn't get the result that you wanted isn't a basis for an infraction. But if an attorney is stealing money or advising the client to, there was just a case that just came out where the attorney was caught on tape advising the client to lie during a deposition. So it
Or
was-
like those hypnotist people, right?
right,
Yeah.
We have a
right.
fiduciary duty to our clients, just, you know, like so many other fiduciary duties, and that's to act in their best interests. So they can actually Google the
Yeah,
code as well.
yeah, the code is available online and really easy to find, that lists everything.
Okay, Shelby,
all
that
the
was for you.
Okay, and then we've had some discussion or some questions about visiting judges as well.
Yeah.
Um,
You guys
would
want to talk on that?
Yeah, okay.
Sure. Well, you know, in our court level, we try to provide both civil attorneys and criminal attorneys the highest level of trial date certainty possible. So the knowledge that if you cannot resolve through plea bargain, or if it's a civil case through a settlement, that you're gonna have your day in court where you can present your case to the jury, and it will be decided on its merits or its lack of merits. And that trial date certainty is so important, and ruling date certainty, to keeping the system running efficiently. And fortunately, we have visiting judges for if there is a conflict. For instance, if I'm starting a murder trial on Monday, but there's a big civil case, oftentimes with the attorneys, it doesn't matter who they're in front of trying it. They want that trial date certainty because they have people flying in. They've spent lots of money. They've worked hours over the weekend preparing for the case, so they need to get in front of that jury and present it. So we'll have visiting judges across the street where we can send the case over and give them the trial date certainty that they deserve. Sometimes they want to stay in front of the judge that they've been in front of the whole time because that judge is familiar with the issues, and then in that case, you know, we can give them another date, or we can back the case up. What we don't want to see happening is civil attorneys arriving at the courthouse and being told by the bailiff, sorry, you're not going forward on your case today, we're going forward on another case. When you have, you know, that costs the system, you know, completely unnecessary cost and very frustrating for civil attorneys. So we've tried to eliminate that at the trial court level.
That's a huge, and I heard a rumor that even if you're successful, you're gonna try the cases on your docket until the day you leave. There's a few
Oh,
set in
yeah.
December that you have scheduled.
Yeah, if I'm successful in this race, I have some big civil cases set, and I've assured the attorneys that I will sit through those cases.
Yes.
All right, caller, go ahead. Caller?
Hey, you're on the air. Live. Did we lose
Maybe
you?
not.
Maybe not, you don't want to say nothing.
Okay, well, is it common that most visiting judges are retired judges from other courts?
That's how it's
Good
been.
question.
That's how it's been, and we have some great, you know, you're forced in the state of Ohio to retire once you reach the age of 70, but, you know, we have some great judges who still have all their faculties. 70 is the new 50, right?
But the rule is they have to retire as a judge in
Right.
order to serve as a visiting judge. And
Right.
the Ohio Supreme Court Chief Justice appoints who's gonna be a visiting judge.
That's correct.
Is there any oversight amongst judges for retired judges who are starting to lose their faculties?
Oh, yeah, good one.
Yeah,
I'm
that's
getting
the-
to her question by the most,
Yeah.
diplomatic way possible. I
Yeah,
suppose.
that's the Supreme Court's function.
Okay.
They have oversight over all the visiting judges and appoint judges for those cases where there's conflicts on the trial court, or sometimes an entire court has to recuse itself because they know one of the parties, and you bring in another judge from another county, sometimes a visiting judge. So the Supreme Court has, and the Chief Justice has complete oversight over
And as
that.
a practitioner, if we see something like that, we also report it.
Of
I mean,
course.
I've had that
And
problem.
then how long would it take?
Well, then it goes to the Chief Justice of the Supreme Court to investigate and look into it if there's
But
validity
how
to it.
long?
It's
just
been
got
my
out?
experience that it'll be addressed quickly. I mean,
Is
you don't
it?
want something like that to occur.
One more question about the visiting judges. Maybe I'm wrong, but in juvenile court, there was a visiting judge for a long time. So do they stay in one place, or they're truly visiting? They truly go one place to
That
another?
was 30 days.
Yeah,
Is it 30
there's a
days?
rotating basis, so that the list of visiting judges that exists out there get an opportunity to come in and try cases, because
It
there's,
might be a 90-day window. I'm not
Yeah.
sure that they then serve, so no one's supposed to be there for a long period of time.
Okay.
Okay, I'm getting the stop signal from,
Yeah, it's time for you
Mr.
guys
Larry.
to get back to your campaigning today.
As you
Sorry.
can tell, I
So-
apologize again for the attire, but it's a
Hey,
big day today. We've got a lot to do.
Absolutely.
Get people out to vote. If they
Yes.
don't-
See, I voted by mail.
it's a beautiful day that,
And the
Early-
Board of Elections is open today from
Yeah, that's
1
amazing.
to 5.
Amazing.
Please come down and vote.
Well,
Yes.
good luck to both of you. We hope you both get elected.
thank you,
you
thanks
very
for having
much.
us.
You're
Appreciate
welcome.
it.
Thanks for coming out.
Thank
Now
you.
you're gonna go behind.
We'll
and
go
we're
this
gonna-
way?
Okay,
Okay.
Judge Rini,
Thank you.
we're gonna.
Great to
Oh,
see
you
you.
put us
thank
off?
you, that was
Of course,
great.
thank you.
Yeah, that was great. Hi. How are you?
Maybe.
Now we're back
All right.
with
Welcome back.
Judge Rini and Magistrate Janine. It's Nickerson, right?
Yes, ma'am.
Welcome.
Thank you.
Welcome back. As a matter of
Yeah.
fact, you were on our show a few months ago,
Yes,
and it is now the height again of campaign season. And,
it is.
And
How many days? How many
2.
hours?
Calculated.
how's the campaign run been, Your Honor?
It's been busy. The good part is I really like talking to the community, explaining juvenile court, because my biggest issue is, in order to solve the issues about delinquencies and the seriousness of the aggravated robberies and the murders that I've been saying, I need the entire community to come in. I need them to come into my courtroom, I need them to go to the detention center, I need to have wraparound services. We refer them out to the mentoring program, so I need the community, and that part has been awesome.
I see you're always in the community. I told Erica, I get tired of watching you because you're at this event, you're always out there, and good for you. You know, we really need that. I don't see too many judges making the effort that I see you make.
And the hard part is the fact that this isn't the way to choose a judge. Because what you should do is you should have independent people, kind of like judge for yourself, but with a little bit more money behind it to get it out there. And they should really determine whether you're doing your job or not. And are you doing your job well? Are you showing up for court? I mean, we work, my
Well,
team is there all the time.
Let's talk about that. You have a 4-point rating?
Yeah,
And, you know, I've worked in the system for 20 years on and off, and I've never had a complaint about you ever, which is unheard of. People complain about everybody, but never you.
well, they complain to me.
Well, they might complain to you, but never to me, so all good news.
It is good, and
Yeah.
we really try, you know, a few people have asked me why, and I said, because I treat everyone with respect.
You do.
Because they are going through the worst part of their life. And I did 2 murder trials last week, and it's
Wow.
heartbreaking that these 17-year-old kids have no idea.
I was gonna say, you're in juvenile court and you're murder?
So it's a matter of transferring them to the general division, to, Judge Donnelly.
Yeah, to try them as an adult.
But I absolutely agree with him in truth and pleas. I will not take an allocution from a youth that can't tell me what he did. And what he tells me what he did doesn't match what the charge is, I won't take the plea.
Oh, good for you.
How can they trust us?
Right.
If we make them eat charges all the time, and they said, I had one kid, he had 18 charges. He said, I did this, I did this, I did this, I did this, I didn't do this, I did this, I did.
Wow.
Prosecutor says he's got to eat them all. I'm like, we're taking them all to trial then, and I said, I'm gonna have Magistrate Nickerson take some of these. And then they said, so then he allocated on all of them, and the last one he couldn't allocate, and I said, we're setting it for trial. And I just did the trial, and it's been like a year and a half. That's how long it took.
Wow.
Wow, poor kid. So, aside from, why don't you give our listeners a little bit of the breadth of what you do as a judge at juvenile court? I know you, in general, handle criminal. You're talking about criminal cases and delinquencies as it relates to children. What
Yes.
other types of cases do you regularly hear?
We do private custody and child support, and
Okay.
I don't spin anything off to the visiting judge. Unless I have a conflict for one reason or another, I won't spin it. Because I would practice juvenile law, and I practice domestic relations, so I'm really very well versed in custody and child support. So I don't need to spin it off. Judge Floyd and I are the only 2 judges that actually hear those cases. And I usually hear the high conflict ones, when you have the big attorneys come in and they're like, well,
Yeah.
I'm not settling for anything. I'm like, okay. So I'm gonna try it.
Yeah.
And then we do traffic, so that 16-year-old zooming down the street is, my responsibility. And most of the time, because of the cost of insurance, you have kids that are stealing cars, driving without licenses. So that actually, part of that's traffic and part of that is in the delinquency realm. And then we do abuse, neglect, dependency. We had in foster care we have about 2,500 children in foster care, where several years ago we only had under 2,000. So the opioid crisis is kind of really tightening our magistrates on the abuse, neglect, dependency. So if we do an abuse, neglect, dependency and temporary custody is awarded to Children and Family Services, when that 2 years is up and the parents fail to remedy the issue, they come on my docket and I do the permanent custody. And that is the worst part of my job, is terminating parental rights. It
Right.
breaks my heart, because it's not always drugs. It's mostly mental illness.
That's very sad. So you have Magistrate Nickerson and other
Yeah.
magistrates that support you in the breadth of your work. How many magistrates do you have working for you, Judge?
I have Magistrate Kay Ranke, who does the abuse, neglect, dependency, and Magistrate Janine Nickerson, who does the misdemeanors and the F4s and 5s. We have traffic, so 3 of us share Magistrate Amato, and then 2 of us share Magistrate Kovacic and Magistrate Leonetti, which are support, and then Judge Floyd and I share Magistrate Williams, who does a lot of the pro se private custody ones that come in, because they're so time consuming, and no matter how much you explain the law to them, they don't want to hear it. Moms come in and go, it's my baby, and no one's getting, I'm not giving them any parenting time. So it takes a lot of energy and time, because under Ohio law, the mother's the sole legal custodian of the child born out of wedlock.
Yeah, until such time as the father establishes paternity and files a complaint.
Yep.
And then things start to change the other way. And then you're right, a lot of the women that I represent aren't exactly excited to hear that, shall we say. Is it easier when you have a private custody case where there's attorneys involved versus having them pro se?
Well, I don't have to explain the law because that's their attorney job or the GAL's job to do. So that makes it easier. I was at a meeting at 860, the laborers union, who I love those guys, and I said, guys, if you're gonna have a baby, marry her, because
That's
if
what
you
I say
don't-
all the time too. Yeah, to my children, marry her. You get her pregnant, you better get married.
And you can get divorced within 6 months.
That's what I said too.
But the whole point is get married so that you stand on equal footing immediately.
Right.
And,
And we really can't say that enough. Eric gets mad because we say that on every show, but it's the truth. marry her if she's pregnant.
And don't sign the birth certificate.
Wait a minute, what?
That's what I'm learning from my paternity case. There's no advantage to signing the birth certificate. If you're married, the child is presumptively yours under the law. Isn't that what we're...
You don't have to sign it, and if you're married. then
Right,
you
right.
should go
So
on
you're
with
just
it.
talking about people who are married.
Right, I'm just talking about
But-
people, if you are married, you should not sign the birth certificate. If you
However-
are not married, that there may be a benefit to it. But if
There-
you
I-
are, and please don't cut me off. If you are married and you sign the birth certificate and the child turns out not to be yours, you can still be on the hook for child support for years and years and years to come for a child who's not yours.
Well, I've had a couple cases where they were married. I had one case that I was a guardian ad litem for, where they were married, they got divorced, they did the parenting agreement, shared parenting plan, and then the mom got remarried and said, oh, by the way, the youngest one's not yours.
Yeah.
So they were in domestic relations court, they were in juvenile court, and it was a cluster.
Exactly. And I just had one referred to Judge Baczynski, visiting Judge Baczynski, that is on a similar issue, and it's probably it's the most hotly debated case that I have, and that seems to be paternity in particular, and the rights of biological fathers versus the raising father. It's a very emotional and difficult issue for a lot of people.
And here's
that's what I'm saying.
my issue with that is, if the child's 8 or 9 or 10 years old and that's the only father they know, they should not be able to have any relief from paternity. That is because that's what the case law used to be.
Right.
It's swinging the other way now, where biology is trumping, and biology should never trump when it comes to children.
Okay.
I'm not understanding that. Biology should never trump.
I had a case that I was the attorney for the dad. So here's what happened. Woman was married with another, and they had a child. And then they were separated and then hooked up or had a child with my client, and then decided after she got pregnant and had the baby, even though my client was there in the delivery room, decided to go back to her husband and have a third child. Now, in that situation, I kind of agree that you should have rights as a biological father. But if you just step out of if you step out of your marriage and you never know that that child's not yours until 10 years later, that's a little different.
Yeah, I agree with that.
Now, the case that I have is that the biological father never knew of the existence of the child at all. And then when he finds out later on that the child exists, he's like, well, I would like to have some rights and develop a relationship with child. And, that again, I think is a more sympathetic scenario for the biological father than, being just, coming out of the clear blue sky and being, completely, trying to assert themselves when they knew about it initially and went away for whatever reason that they did and left somebody else be responsible.
Well, let me ask you a question. Did your client know that she was married?
Did not know that she was in a relationship at all.
See?
Yeah.
I mean, so I think their facts are specific.
Yeah, of course they are, right. And our law, at least that I've read, it doesn't really give a lot of wiggle room for the fact specificness of a variety of these cases, the breadth of human experience. Would you agree with that?
Not anymore, but I do have a ton of briefs and motions that we wrote. If you want them,
Yes,
I still
please.
have them because it does. I mean, we papered the heck out of the case that we did because that's the only way we could do it. And Steve Wilkin was on the other side, so it was a battle of paper.
Okay, I'm going to read a couple of these questions before asking. I'm getting some text message. You have a question
good.
for the judge?
The same thing that always comes up, Your Honor. GAL program. The last time you were on our show, you were discussing that Cuyahoga County now has CASAs,
Yes.
correct? Is that helpful for the guardian ad litem?
It absolutely is. And the more persons or professionals that can wrap services around a child, the better we are.
Are the CASAs free of charge?
They are.
So would you have a guardian and a CASA?
Yes.
Both.
Yes. And-
But that gives you extra protection.
Well, in the court-appointed special advocate program, I mean, although their services are free, it costs about $500,000 to run the program.
Wow.
So there's that, because they have a fairly large staff, and they have to go out for donations. I mean, there's some areas. I think ours runs at probably maybe a $300,000 a year. So nothing is free, but the
To the client.
volunteers- Yeah,
Yeah.
the volunteers are, and they're lovely. We use them for protective supervision, and that is helpful to the family.
So if you're in juvenile court, you have a guardian, you can request a CASA? worker?
No, we use them for protective supervision, meaning that we want to keep the children in the home with the parent. So the more services, like sometimes it's an educational neglect problem, or maybe there's not electricity, or like there's all these little things that we used to remove right away, and now we find out that that creates trauma.
Oh.
So, but if we keep them in a home that continues to be dysfunctional, that creates trauma. So having a CASA there and a guardian ad litem, see what services do they need? Is it transportation? Is a child going, like, I don't understand why Cleveland school system, you should go across town. Why should you take 2 buses of
No,
town
I
and
never
plan
got
to
that.
school?
Right.
You should go to school in your neighborhood.
Right.
So if that's the issue, does a child need an IEP, you know, the individual education program? What does the child need? And a CASA can help. Because how do you take a mom that might have 3 or 4 kids and say, oh, you know, this is what you should do for your child? She doesn't, they may not have any idea.
Correct. And that question was for Elizabeth. Thanks for writing in. Eric, you said you have some questions for people?
Okay, so this is a question from Shannon. I'm going to paraphrase it a little bit. The question is essentially along the lines of, how does the court determine the fitness of parents in private custody cases? Is there ever, have you ever seen a private custody case rise to the level of where one parent was determined to be unfit?
Oh, yes.
Determined to
okay.
be unfit?
Yes, and can you explain to our listeners why that determination is important?
Well, I have, I think, 2 cases on my docket now that came over from domestic relations.
Okay.
And the misconception is, if a case is in domestic relations and they say the parents are unsuitable, doesn't mean that we're going to fix them in juvenile court.
Both parents we're talking about?
Both parents. So if you're going through a divorce and you just know, like they did the family conciliation or the FCS report, and they said these parents are, so they sent it over to juvenile. Well, it comes on my docket. It comes on my private custody docket. It doesn't get referred to Children and Family Services. That, I think, is inappropriate, because it should go right to Children and Family Services, because obviously they're the ones that are going to determine whether these parents need a complaint written against them.
Yeah, what did they expect you to do in your court?
I have had, when I was practicing, I was in front of Judge Carner, and I said, Judge Carner, if you send this over, this is what's going to happen. And she said, I don't believe you. I'm like, okay. And so it goes on the private custody docket. And we don't have any other services in that realm than domestic relations court has. But what you do is you send it to the diagnostic clinic. You know, we do a psychological evaluation, we do custody evaluations, and the juvenile court diagnostic. And that we do are way better than the domestic relations, because we have clinicians that are PhDs that will do the reports. But that doesn't mean, like, is it situational? Like, are the parents, just because their marriage is breaking up, they're happily ever after, is devastated, is that situational and they're really okay once they get past the heartbreak? Listen, you never want to have a girl that's heartbroken, because we'll find you.
I'll keep that in mind. Thanks,
Right?
Judge. That's very important advice.
You know, and that's the big difference with juvenile court. With juvenile court, you don't really have that marriage. You don't have that fairy tale. You don't have that happily ever after expectation. You know, you might have a long-term relationship, but when you get married, you expect it to be forever.
Sure. So what are the important factors in determining whether or not a parent is actually unfit to be acting as a parent? And isn't the consequence that if they are determined to be unfit, their parenting time or their rights to parent are cut off?
No.
No.
Their rights to parent are never cut off, but
Okay.
they can be curtailed.
Okay.
Like, I always start in the position of shared parenting. I presume 2 parents come in and they should be shared parenting. They should be
Right.
stand on equal footing. I had one case where the mom, they had a baby who was 7-month-old, and I gave dad parenting time, and she was like, well, he's this and he's that, he's domestic violence. I'm like, all right, fine, we'll do supervised until I get a guardian ad litem to investigate. She broke down hysterical, 4 hours on a Sunday. I said, we'll do this, we'll put it out 3 weeks, because it's got to move fast if you're going to bond with your child. She goes, but I don't really know him. I said, you have a baby with him. I don't know what to tell you.
Yeah.
He still has rights. As it fast forward a year, dad has full custody. Because
Wow.
mom, opioid addict.
Ah,
See, so those are the things that, but she still gets parenting time.
okay.
So we don't cut their rights off. All we do is curtail access to the child.
Now,
Okay.
how did you guys find out that she was an addict?
Well, she kind of had a little incident where she lives, and the police were called, and she got a 7-day hold at a hospital,
Got it.
and Children and
Wow.
Family Services stepped in. and wouldn't give the baby to the dad until I ordered it.
Right.
Is that why you take your time with these cases and give a few opportunities for a guardian ad litem to be involved and you continue a case maybe once, twice, or 3 times to allow the story to develop? Or
That's part of it. The other thing is sometimes they just have to get used to it. Like I'm one of the few jurors that will order temporary orders. So the minute a case comes in, I kind of get I hear from everyone, and then because I don't want, you know what happens is 3 months goes by and you still don't see your child. Like, and the
Right.
child might be a year old, and you lose that. You never get that time back. So I always do temporary orders, even if it's support and parenting.
But not every judge does that, you're saying.
Right. But
That's good to know. I really thought they did.
like some of them do, and I don't want to say that blanket wise.
Because, yeah, it could be heartbreaking to go, because when you file in a juvenile court, first you go to mediation, then if you don't agree, you go over to court, and right there's a period of 2 to 3 months already that they've waited. So how disappointing is it when you get into court and you don't get a temporary order for access?
We're much better at that though. We get it in a lot quicker than 2-3 months now.
Oh, good. That's good to hear.
So if there's a Rule 13 or emergency custody,
Yeah, right.
my group will handle it, and they will handle it within a couple of weeks, depending on what it is.
Talking about emergency custody, sorry to cut you off.
No,
How long, if you file an emergency custody, how long does the court have to hear your case? And what if they don't hear it in that amount of time?
well, depending on what the affidavit says, like we've had cases that come in and it really truly hasn't been an emergency. The affidavit's like, mom won't let me see the child, or the child's, missed school on Friday, or I missed my parenting time. So that's not, if the affidavit isn't really truly emergency, we usually get it in within 2 to 3 weeks. If it's an emergency, like mom was found in a car with, the child and, she was doing drugs, that's a little trickier because either Children and Family Services should be called immediately, or we've had ex parte hearings, like the one parent will come in and they'll testify as to what the immediate danger is, and we will either say, yes, you're gonna make you the temporary legal custodian, and then we have to get it in within 72 hours. And my group does that.
Say the father has physical custody of the children, that would be considered an emergency custody situation, right? Mom's nowhere to be found, dad has physical custody of the children.
Well, it depends. How old are the children? Is he not able to get the medical care? Is there a medical issue?
So it might not be considered an emergency?
It might not be. He's the dad. I presume what's frustrating for me is when a guy comes in when the kid's 7 years old and has been like, oh, well, I have this child. Like, where have you been? Like, why didn't you file? Well, I had one client that 7 years old, the child was 7, and the mom said, I'm going to take the child and move to Boston. See ya. When this dad had more than 50% time.
Aye.
And I said to him, I'm like, where were you? He goes, well, we didn't want to be in the court system. Get that. But you can still file without making it adversarial.
Yeah, I think that's something that a lot of people don't seem to know. I've had to advise quite a few people about that. They'll come to me and it seems like they have a pretty good arrangement going on, but they're afraid that may change. And it's like, we can file and do an agreed judgment entry at the first pretrial and be done, and just put something on the record, and that's going to be your quickest court case ever. It's worth doing just to prevent that kind of a circumstance where somebody moves to Boston and they're gone forever, or at least mostly gone forever.
We got the child back, and mom
Did you?
moved back with the child. Yeah,
Wow.
They ordered the child back. We can't order the mother back per se, but the judge, who was a visiting judge at the time, ordered
Okay.
the child back, and then mom decided that she was important for her to be with her child.
Is there any states that are harder to work with that on to get a child back into the state of Ohio?
No, if we have competing jurisdictions, we have to have a telephonic hearing, like on the record and talk. So I've had hearings with judges in Florida, and depending on where the evidence is, it's really kind of easy because on the one, they're like, hey, everyone's up there, but the agreement was done in Florida. I'll adopt it as a foreign decree and we will go forward.
Okay. Okay.
Yeah.
Well, that question was for Shannon. Hope that answers your question. Do you have anything else you'd like to ask the judge? Or we can talk
I
about
think
campaign for a minute.
yeah. Tell us about your campaign.
I love going out to the community and speaking about the youth and the families and the children. As I said, I had 2 murder cases last week, and my frustration is I want people to be engaged, I want them to listen. I had one, and it technically wasn't a murder, it was involuntary manslaughter, but I had groups of young boys just shooting at each other. So the police testified and they said, yeah, there's, where 40 calibers were found over here in this cluster, and 16 millimeters were found here, and 9 millimeters were found here. And I just keep thinking to myself, how is this possible? How is it that these young boys, all in a group in Maple Heights, are running around shooting each other as if it's the Wild Wild West?
Yeah.
Where have we failed that these guns are just literally in the hands of these kids? And it's heartbreaking because they had no idea. I don't even know if they were trying to kill each other, but one of the bullets hit someone in the chest and he died.
Aw.
Yeah, and so I have the family back there who's, hysterical because they're watching these videos because it was at a school, so they had video surveillance all over. And that part, I need the community to come into my court. I need to do wraparound services. We started a program with Magistrate Nickerson and I, where she has the reentry court, which are the kids that are coming out of ODYS. And we started a program and said, I can't make you go to church, but I can make you go to a church in your neighborhood and sit down with the pastor. You're gonna sit down with the pastor, you're gonna tell them what you did wrong, or why you're there. And you're gonna go with your probation officer, because that's the only way they can be accountable. And you're gonna ask the pastor to assign you a mentor from their men's group, because almost all the churches have men's group. And you're gonna talk to that person every single day. I want you to tell them, did you have a good day? Did you meet a cute girl? Was the girl nice to you? Did someone break your heart? Was school hard? Was a math test hard? Like somebody just that they can connect with.
Good idea.
Do you think that that's lacking at home? Is that why you're
I think
ordering these?
I think it is lacking at home. And I also think that we don't do a good enough job in our probation department. I think we need to step it up and really engage the community.
Okay. I'm not going to address issue 1, but I am going to suggest that because of the conversations about issue 1, that there's been a lot more awareness of drug court at the Cuyahoga County Court of Common Pleas. Is there a similar program at juvenile court?
I am the teen drug court manager or jurist, and yes, we have youth on our docket that, for whatever reason, just won't stop smoking marijuana, and a lot of it is because their parents smoke, and that crosses socioeconomic divide. It crosses suburban lines because out of all of the delinquencies we have around 5,000 youth, and like 2,300 are from the inner city, and like 2,500 are from the suburbs. So we have an even distribution. This is the first issue that our Chief Justice has said we can speak on, and really because she's not in favor of it. All of us are in favor of treatment. I don't know that there's a judge that says if you get caught smoking marijuana or doing drugs or heroin or benzodiazepines or whatever it is, that you shouldn't get treatment. The problem is we do that already, so we don't need to add a constitutional amendment to a constitution that's already over 200 amendments. The casino's in our constitution, Marcy's laws in our, so that's the big issue with issue 1. I'd like that segue. So we already do that. We already get treatment, and only until they just keep violating our orders do we send them somewhere. And usually it's for treatment or just to stop using long enough so they can clear their head.
Do you think there's a need for more funding for inpatient treatment in Ohio?
Inpatient treatment. See, the problem, the concern, what I hear, because I've done a lot on brains and trauma, and my background is psychology, it's not long enough. We can't send someone for 90 days and expect it to be, poof, they're cured.
6 months? A year? Do you
They
think that
say
would
it's
make a
gotta be a
difference?
minimum of 9 months. That's what the experts tell us.
Okay.
We have about 30 seconds left. Do you want to give one last plea for people to vote for you? Because I know I did.
I appreciate that.
You're welcome.
Well, what I want everyone to understand is don't look at the Slate card, whether it be Republican or Democratic. Look at Judge for yourself. Look at any other thing to see what we are doing in our courts.
I am the perfect example of that. I'm very blue, and I voted for Denise Rini.
And I appreciate that.
You're welcome.
I'm in the same boat. I would consider myself on the blue side of the aisle, and I think
Yeah.
you're an excellent judge.
So do I.
And I would never have guessed, that an R is behind your name until I, learned a little bit more about your political side.
And who else is an ours? McClelland, and they
Yeah,
love
right.
him.
Oh, McClellan's fantastic.
But the politics of our county, that's really kind of what we have to do is designate, and it's awful.
Yeah. Okay, I think
All
we're
right.
just
Okay.
about out of time.
We are.
All right, thanks so much, everybody, for listening. Thanks,
that was
Judge
quick.
Rini, for joining us. Thanks, Magistrate Nickerson, for hanging out. And